Hello all. So now we'll be discussing about these things: presentation up till the interlocutory order. There's from order 7, 5, 8, 9, and order 24, 25, 26, 38, 39, and 40. What does it speaks about? Presentation up till interlocutory order. It is presentation of plaint. First plaint is presented and service of summons. Summons is served to the opposite parties as per order 5, and as per that the parties will appear before the court under order 9, and if they don't appear, ex parte decree will be passed and filing of written statement by the defendant, and last is interlocutory orders, right? So plaint. So how plaint has to be? Plaint order 7. So in the plaint, what should we mention? The name of the court, details of the plaintiff, details of the defendant, subject matter of the suit, what is the subject matter, and next, cause of action. What is the cause of action? These two things are very, very important, subject matter and cause of action. And if plaintiff is a minor or unsound, the statement related to it has to be mentioned, and facts showing the court's jurisdiction. It has to, the parties should tell it is your court who has the jurisdiction. And next, the reliefs claimed. What are the reliefs? This is also very important. Reliefs. What are the reliefs claimed against the defendant? And is there any set off or a relinquished portion of the claims, if any, that has to be mentioned. So plaint should contain all these things. Plaint order 7. Okay. Next, if it is a money suit, it has to mention the amount that has to be recovered, and if there is any interest involved, the interest rate has to be mentioned. And if it is a suit related to immovable property, it has to mention the schedule of that particular property. And plaint must show the defendant's liability. What is the defendant's liability? This is the very important role of the plaintiff. In plaint, he has to mention the defendant's liability and reliefs claimed by the plaintiff against the defendant, and the copies of the plaint along with the fees of serving the summons. Summons serve ಮಾಡಕ್ಕೆ court fee payment ಮಾಡಬೇಕಾಗುತ್ತೆ, and that is done as per order 5, rule 9. Okay. Next, return of plaint. Yavaga, when there is no jurisdiction, what happens? The plaint is returned. Okay. Plaint is returned. And date of presentation. While returning, the judge has to mention the date of presentation, the date of return, details of the parties who have presented the plaint, and very important, reasons for return. Judge has to mention why he is returning the plaint. Okay. And order of return, very important. Order of return is appealable. It is appealable. And rejection of plaint. If there is no cause of action, if court feels that there is no cause of action, it can reject such plaint. And relief claimed is invalid, then it can reject the plaint. And property valued, the valuation of the property is insufficiently stamped, then it can reject the plaint. Okay, these are the certain conditions related to rejection of plaint, and reasons for such rejection has to be mentioned by the judge as per rule 12. Okay. And next, as you can see, rejection of plaint shall not stop the parties from filing a fresh suit. They can initiate another suit in future. Next, production of documents. Production of documents, as you can see on the screen. One second. Production of documents related to relief claimed. Okay, so they have to produce the relevant documents related to whatever claims they are making. Correct. Next, if it is a document which is a negotiable instrument, it's related to negotiable instrument under rule 16. If it is a negotiable instrument, the court has to be satisfied that such negotiable instrument is lost. For example, check. They have issued a check and you have lost it, and you have to reclaim it. Then the court has to be satisfied. Who has to satisfy? The party has to satisfy. So rule 16 speaks about loss of negotiable instrument. So this is the explanation for your convenience. Okay, now next, order 5 speaks about summoning the defendant, and order 8 speaks about written statement. So 5 and 8. Summoning by 5 just looks like 5. It looks like S summoning, and it is written statement. Written statement. Okay, by the defendant. So what do you mean by summon? Summon is nowhere defined, but however, we have a general definition of it. It's a document which is issued by the court to call the parties to be present before the judge for a specific reason. So this is called as summoning, summons. Okay, so what is the objective of summons? It is a legal action. It is an opportunity given to the defendant to present his case for whatever claims has made against him, whatever the claims that the other person has made against him, and is revolving around the concept of audi alteram partem, that is the right to be heard. Next, if the summons are served, it has to follow the principles of natural justice, that is right to be heard, very important. Next, presence of either a witness or accused. Summons can be issued in order to make the witness come, or even the accused come, to ensure that even they appear before the court, and in order to produce certain necessary documents. Summoning of person, summoning of documents, both are very important. Okay, next, essentials of summons. What are the essentials of summons? It has to be duly signed by the judge. Judge has to sign it, and it has to be sealed by the court. Court seal should be there. It has to bear the court seal. Very, very important criteria for the summons to be a valid one. Next, summon. After the issuance of summon, after summons are issued, you know, the written statement has to be filed within 30 days and should not cross more than 90 days. All right. It has to be accompanied. Such summon should be accompanied by the plaint. Photocopy of the plaint has to be accompanied. And format of summons, as you can see, format of summons is given in first schedule of CPC. Simple. Next, contents of summons. What are the contents? Date. It must contain the date and day on which, date and day, that is same, date and day on which the parties have to appear. That defendant ಯಾವಾಗ ಬರಬೇಕು court ಮುಂದೆ ಅನ್ನೋದನ್ನ specify ಮಾಡಬೇಕು summons ಅಲ್ಲಿ. Court has to mention that, and list the necessary document that has to be produced before the court. The court has to say in the summons that these are the documents that you have to come while that these are documents that you have to get while coming to the court. So that summons will also include that particular details. Next, section 27 and 28, very important. 27 and 28. What does it tell? Summons must be issued to the defendant in order to answer the plaint through a written statement. Section 27. What does section 28 speaks about? It states that if it mentions that where summons is issued to defendant has to be sent to a different state or jurisdiction. Jurisdiction vyathyas agidre, the court will send the summons to a court having the jurisdiction. Correct. Proper jurisdiction. This is related to jurisdiction. Section 8 is related to jurisdiction. Okay. Next, appearance of defendant. Appearance of defendant. Rule 3. He appears by himself or through his pleader, and at the same time, court has the power to call defendant at any time whenever it feels so. So, appearance of defendant. Next, exemption from appearance. Very important. Section 113. Section 113 gives certain exemptions related to non-appearance of defendants. Who are those? President of India, Vice President, Speaker, all these dignitaries, VIPs, they are not entitled to appear. They can be presented by through a pleader or their secretaries. If at all, if they need, then the court may decide. Initially, they are not asked to come and present themselves before the court. There is an exemption. Next, mode of service of summons. Court can send the summons. Rule 9. Plaintiff himself can go and serve the summons. Rule 9A, and through post. Rule 20A. 9A and 20A. Next, refusal and objection towards the summons. If they refuse it, refusal if they have refused it, then what happens? If they have refused it, refusal to accept, then it leads to delay of proceedings. Correct? It leads to delay of proceedings. That's right. But at the same time, refusal, if they refuse it, it is deemed that summons has been served on him. If they are refusing it, it will be deemed to be served, or escape ಆಗ್ತಿದ್ರೆ, but still it will be deemed to be served. As you can see, this case law. Puvada Venkateshwara case, in this case, it was held that if the defendant is refusing to accept the summons, it will be deemed that the summons is being served, duly served. Next, objections to service of summons. So objections ಎಷ್ಟು ಬೇಗ ಆಗುತ್ತೋ ಅಷ್ಟು ಬೇಗ objection ಮಾಡಬೇಕು. Objection should be made at the earliest stage. Should not delay. Delay is not accepted. Very important. Next, conclusion. Summons, as you are clear that it is mentioned in order 5 of CPC. Order 5 of CPC. And why it is required? And it is like it is giving the right of the defendants to appear before the court and express their point of view through a written statement. So summons are takshana and follow the written statement. All these things you are very well clear. So this is order 8. Order 8 speaks about filing of submission of written statement. And next, non-appearance. Appearance and non-appearance. Appear aaytu antandre the suit will continue. If they don't appear, ex parte, as we all know. So court will fix a day for appearance and answering that particular suit. So if they don't appear, then it will be dismissed. So when it is dismissed, dismissal of suit, when it is possible, not being served upon the defendant. Summons is not being served upon the defendant because plaintiff failed to pay the cost. If plaintiff has failed to pay the cost of court fee pay madilla, so that is the reason summons does not reach the defendant, then it is subjected to dismissal. And neither party appears. Parties are not appearing. What will the court do? It will dismiss it. And summons returned unserved. But plaintiff fails to apply a fresh summons within 7 days. X has sent summons to Y, but it has returned because maybe Y is not in the place, and X has failed to resend it. Then what happens? Dismissal of the suit happens. Next, can plaintiff may bring a fresh suit after dismissal? Dismissal at takshana fresh suit tarboda? Answer is yes, but only if court is satisfied, as you can see on the screen. Right. Next, procedure when plaintiff appears. Summons duly served. Suit shall be heard ex parte. Only plaintiff is appearing. Defendant has failed to appear and summons is served, and it is subjected to ex parte decision. When summons not duly served, what happens? Second summons can be sent within 7 days. Like summons served but not in due time. Due time hogila summons. Then sufficient time has to be given to whom? Defendant, in order to submit his written statement, and they can postpone the hearing. Postponement of the hearing for the future date. Next, when defendant appears on the day of adjourned hearing. So if there is a good cause for non-appearance, a day will be fixed for appearance and hearing will be done. Defendant appears at the last day of adjournment. So then defendant will be given another chance provided that he satisfies the court. Next, where defendant only appears. Defendant only appears. So suit is dismissed. If plaintiff has not appeared, defendant has appeared. Only defendant has appeared. So what happens? Plaintiff has not come. That's the reason such suit will be dismissed. Suppose defendant agrees, admits. You see, this is a specialty of admission. Admits that whatever claims the plaintiff has made, yes, I accept it. I have to give him 10,000 rupees or 10 lakh rupees. I admit it. Then what happens? Court will pass a decree against defendant itself. This is the honesty of defendant. This part shows that if defendant is honest, then court can pass a decree. Next, decree against plaintiff by default. If there's a situation where wholly or partly dismissed under Rule 8, precluded from bringing a fresh suit on the same cause of action. If they have passed a decree against plaintiff by default, it bars the fresh suit to be initiated. Is what this is trying to make us understand. In order to, so as you can see, in order to set aside the dismissal, notice of application has to be served on the opposite party, but he may apply for an order to set the dismissal aside. The court has to be satisfied only upon the satisfaction of the court. Next, non-attendance of one or more of several plaintiff. Non-attendance. So Rule 10, this speaks about in the Rule 10, and it tells permits the suit to proceed in the same way as if the plaintiff had been appeared. So if non-attendance of one or more plaintiff, it is like those who have present, they can continue with the suit. And next, non-attendance without sufficient cause, very important. Without sufficient cause, the court can dismiss the suit. Next, setting aside the decree which was passed ex parte. Can you set aside the decree which was passed ex parte? Answer is yes. This slide gives you the complete picture of it. Next, interim order. When we speak about interim order, these are the provisions: court payment, security of cost, commissions, judgment, and attachment before judgment. Injunction, interlocutory orders, receiver. This is very important. Receiver is very important. I know powers of receiver, appointment of receiver. This is very important. I've already shared the PDF with you, and just revise it. So now in this video, we discussed about presentation of plaint, service of summons, appearance of parties. If they don't appear, ex parte decree, and an ex parte decree be set aside. All those things we discussed, and filing of written statement by the defendant, order 8, and next, interlocutory proceedings. So I hope you got the clarity about the topic. Thank you. All the best.